Right, good afternoon, everyone, and welcome to today's seminar on Brexit and tax. Where are we in the tax world after the ending of the transition period? We have a stellar panel to talk to you about these issues. In order of appearance, Valentina Sloan, QC, talking about VAT. Talking about the Trade and Cooperation Agreement, Andrew McNabb talking about VAT, Ian Rogers QC talking about customs, and Frank Mitchell SC talking about the position of Northern Ireland. So I'm going to start off with asking Val a question on the TCA, and the question I'm going to ask Val is, can you tell us what the Trade and Cooperation Agreement signed on Christmas Eve means for tax post-transition?
Thank you, George. As it happens, I have some slides addressing exactly that question, which I'm about to share. So yes, the Trade and Cooperation Agreement is interesting because it is not a replacement of the frameworks that we are used to in European legislation for VAT, for customs, for anti-dumping duty. It is a high-level framework. I'm going to be talking through about how it can be deployed. It's not directly effective in the way that we're used to with European legislation. And what is very clear, and we hope to help you navigate during the course of this webinar, is there is now a complete morass of different pieces of legislation, regulations, decisions, which when pieced together, replace the framework that we are used to. And one of the difficulties is actually identifying where to look for the different pieces of tax legislation which now apply across the board. And by tax, I'm covering VAT, customs, anti-dumping duties, tax as state aid, or as it's now going to be a subsidy. So what I'm going to deal with is the Trade and Cooperation Agreement. And what's interesting is what actually it doesn't cover. There isn't that much in it. But let me start then. Let me bring up the slides. And there we go. So the TCA, now, first of all, can it be deployed directly? What is it? Well, no, it's not like a piece of EU legislation that we are used to, such as a regulation or a directive. Subject to a few exceptions, it cannot be directly invoked in the UK's legal system. And I've set out there the relevant provision, which makes it clear that actually the parties are not permitted to allow the agreement or any supplementary agreement to be directly invoked in the domestic legal systems of the parties. So it would appear that whatever is said in the TCA is only of interest if it is actually implemented. But actually the position is, unsurprisingly, more complicated and more nuanced than that, because the UK has passed the EU Future Relationship Act 2020. And section 29(1) of that act provides that domestic law effectively is read as having such modifications as are required for the purposes of implementing the TCA, so far as it hasn't otherwise been implemented, and so far as is necessary for complying with the international obligations of the UK. So there is a read-in in domestic legislation. And section 30 of the same act says that a court or tribunal must have regards to Article Comprov 13 of the TCA when interpreting that agreement. And I've set out there the relevant provisions about the summary. It means it must be interpreted in good faith and in accordance with the ordinary meanings. Now, I have said there are a few exceptions to this difficult route of invoking it directly, and one of those is section 22, which has specific provisions relating to the enforceability from the TCA of the VAT and mutual assistance provisions, which I'll be coming on to. Now, if you're particularly interested in this, or it becomes an important point in any of your litigation, there is an excellent article on it by Jack Williams on the Moncton Chambers EU Relations blog, which dissects in real detail how the TCA is enforceable, particularly through the provisions of the EU Future Relationship Act 2020. It's very complicated. I can't cover it here, but if you are interested, take some headache pills and check the EU Relations blog for a complete digest. So what does it cover? Well, the first area that the TCA covers is customs duties. As you've heard, Ian Rogers QC is going to be dealing with this in more detail. So this is a very high level overview. Customs duties are effectively, there is now a free trade agreement. Customs duties are prohibited. import-export restrictions are prohibited, but this is all subject to the rules of origin, which again, Ian is going to be going through. I set out at a very high level here an overview of how products can satisfy the rules of origin. So the free trade agreement only applies if the products are wholly obtained within either the UK or the EU, they're produced exclusively from originating materials in those territories, or they incorporate non-originating materials but satisfy specific requirements set out in the TCA. And as you can imagine, there is a wealth of detail set out in rules as to what each of these concepts means. You might as well be aware that there is also provision relating to accumulation. This ensures that, for example, in relation to car production processes which cross the UK and the EU can continue without the loss of origin. I've set out on this slide a brief navigation of the origin rules. The specific rules for certain products are contained in the annexes that I've set out there. There's a list of operations which are insufficient to confer origin and a set of tolerances which are applicable. There are origin quotas. And what I've also noticed is that the procedural aspects of the origin rules are very important too. Ian will be dealing with this, but if you're an importer or an exporter, you need to be clear on who is responsible for the statement of origin. And if you are responsible, how do you make sure that you are protected either through a contractual indemnity or through some other way to be able to prove origin if it is verified? And I've set out there both a link to the government guidance on this, but also the very recent guidance in the European Commission on origin procedures, where they talk through exactly that. What are the controls, what are the checks, what are the sorts of verifications that traders will be subject to, what are the sanctions? So that's very important if you are involved in any way with origin rules. The second area which is covered by the TCA is anti-dumping duties. Now, again, we used to have a clear set of EU rules on anti-dumping, a set of EU legislation, and there was a test which was EU-wide as to whether anti-dumping measures should be introduced. Now that we have left the EU, there are two ways in which this still is of relevance to us. This is either because there is a domestic industry which wants protection from dumping abroad, or you might be an importer who is going to be caught out by anti-dumping protection which is imposed. This is not covered in any detail in the TCA. All the TCA makes clear is that the parties can impose anti-dumping and countervailing duties and safeguards. The UK's Trade Remedies Authority has now been established, and all I can say at the moment is that traders need to keep an eye on developments by the UK and the EU authorities. The Trade Remedies Investigations Directorate has a very useful website with a lot of guidance. It sets out its procedures, its policies. It also has a list of investigations currently in progress, because of course what it's grappling with is whether it should continue and replicate for the UK market protections which were imposed on the basis of an EU-wide test previously. I've set out there some of the legislation which is relevant, again, illustrating the patchwork nature of the legislation that clients now need to be aware of. The third area covered by the TCA on tax is tax and mutual assistance. As I've set out here, there's a protocol on customs mutual assistance and one in relation to administrative cooperation and fraud in relation to VAT, and mutual assistance for the recovery of claims relating to taxes and duties. So although we've left the EU, HMRC can still seek mutual assistance or be requested to provide mutual assistance in relation to claims relating to taxes and duties. It replicates the EU legislation, as you can see, and there is a specific declaration concerning Jersey and Guernsey. There are also particular rules about the domestic enforceability of these specific tax provisions. So Section 22 of the EU Relations Act, which I referred to earlier, which is this Domestic Act, makes the protocol on administrative cooperation combating fraud and any decisions or recommendations adopted by the specialised committee directly effective in domestic law. So that might not come up in domestic law, that's something to be aware of because it's directly effective, and that's not just the protocol itself, it's decisions and recommendations. And in essence, what does that do? The protocol on VAT and debt recovery commits the UK and the EU to cooperate and share information for the purpose of ensuring trader compliance and recovering tax and duties debts. The next area which is covered in the TCA is tax and subsidy control. People will be familiar with this through the concept of state aid. Tax foregone is a subsidy, it can be a subsidy, but there is a raft of rules on how it can be a subsidy. So effectively, if a set of operators, particularly domestic operators, get a tax break, which is not applied to others, is that a subsidy which can be attacked as unlawful in accordance with the TCA? Well, there are all sorts of rules about the specificity of the tax. It also needs to be overseen by an independent authority or body. And what the TCA does is at a high level set out the procedures, but it is for the UK to implement those. And we'll see what the UK needs to do is have a power for courts to, well, first of all, there's an independent authority looking at this, then a power for the courts to review decisions, the ability to have remedies, including injunctions and orders to recover any sums, and that can be on an application by an interested party. Are there any other constraints on UK tax freedom imposed by the TCA? Well, they're very limited. In Chapter 5, you have tax good governance, which is a commitment to global standards on tax transparency and fair tax competition. I've noted there is the global, not the EU understanding of fair tax competition that needs to be adhered to. And Article 5.2 says that provides for a commitment not to weaken or reduce tax standards below the level agreed in the OECD. There's also a joint declaration on countering harmful tax regimes. These are relatively high level. So when it comes to VAT, there is very little constraint in the TCA. And that is a good moment for me to stop and hand over for Andrew, who's going to be looking in more detail at the VAT position, because that is a canter through what the TCA covers. And what can be seen very clearly is that actually in terms of tax matters, it doesn't cover that much. Thank you very much.
Thank you very much, Valentina, for that. I can't just help just adding on subsidies and tax. It's worth noting that a measure that is contained in an Act of Parliament will not be subject to a recovery order. There's a specific provision in the TCA. But of course, many tax measures aren't in Acts of Parliament, Acts of the Scottish Parliament or subordinate legislation or just decisions, so they could be. So I'll hand it over to Andrew. And the question I'm going to ask Andrew is, what actually does UK exit from the EU mean for VAT in the UK?
Thank you, George. First, I too have slides. I will not speak to them directly or even show them to you now. They'll be available after the webinar. I hope you will find them useful. Second, the phony war is over. IP completion day has come and gone. As from the 1st of January, the UK is now definitively not an EU member state, or, leaving aside Northern Ireland, treated as if it were an EU member state. What does this all mean in world of VAT? On the international plane, the UK left the EU on the terms agreed in the withdrawal agreement. The withdrawal agreement itself contains some material of continuing future relevance to VAT. See Article 51, which has provisions concerning certain cross-border movements and supplies spanning the end of the implementation period, and transitional provisions concerning such supplies, and transitional provisions concerning the use by those in the UK of the EU mechanism for intra-EU refunds of VAT incurred in other member states. You see also Article 99 concerning administrative cooperation and mutual assistance. The main feature of relevance to VAT in the withdrawal agreement is, of course, the protocol on Ireland/Northern Ireland. Article 8 of the protocol provides that various provisions of EU legislation concerning VAT on goods, emphasize on goods, continue to apply, quote, to and in the United Kingdom in respect of Northern Ireland, unquote. And they are listed in Annex 3 to the protocol. And I'm going to leave all of this to Frank very happily too. But by way of spoiler alert, in the world of VAT, just remember this, the UK is not an EU member state. Second, Northern Ireland is treated as if it were a member state of the EU in relation to goods. Great Britain is not treated as a member state of the EU for any purpose, including movements of goods between Great Britain and Northern Ireland. And if you keep that all in mind, you probably won't go too far wrong. On the UK domestic plane, the UK has given effect to Brexit, including the withdrawal agreement, by means of various fiendishly complicated legislative measures, including most notably the EU Withdrawal Act of 2018, as amended by the EU Withdrawal Agreement Act of 2020. The Withdrawal Act as amended provides the overall framework in which the VAT legislation sits. So when you're trying to work out how to apply the VAT Act, etc., you're going to need to look at the Withdrawal Act as amended. In effect, and oversimplifying things somewhat, the Withdrawal Act does this. First, it repeals the European Communities Act 1972, or the ECA, which gave effect to EU law in the UK in the first place. Next, it provides for the retention of EU law as it existed immediately before IP completion day, and this is called retained EU law. Retained EU law falls into 3, 4, or 5 categories according to taste. Category 1 is EU-derived domestic legislation, that is a UK legislation which was enacted to give effect to EU legislation. And this would appear to include fairly obviously the VAT Act itself, much of which was enacted to implement EU legislation, namely the VAT directives, and secondary legislation made under the VAT Act, for example, the 1995 VAT regulations. You may say that this legislation is UK legislation and did not need saving by the Withdrawal Act. You would of course be right, but that would not save the obligation to read it subject to EU law. So this saved legislation is subject to the exceptions to savings and incorporation that are set out in sections 5 and 5A of the Act. Category 2 is direct EU legislation, and basically direct EU legislation, so far as operative immediately before the 1st of Jan, is incorporated into and forms part of domestic law on and after the 1st of Jan. In the world of VAT, this could have covered the 2011 Council implementing regulation and various e-regulations on administrative cooperation and mutual assistance, but the Taxation Cross-Border Trade Act 2018, aka the TCTA, section 42 deals expressly with such measures. Basically, none of them applies, none of them is retained, except the 2011 implementing regulation. And section 42.5 of the TCTA provides that where the principal VAT directive remains relevant for determining the meaning and effect of the law relating to VAT, then that directive is to be read for that purpose in the light of the provision made by the implementing VAT regulation, but ignoring such of its provisions as are excluded by regulations made by the Treasury by statutory instrument. So, for example, at least as I read it, it continues to apply to the application of the rules in section 47.4 to 6 of the VAT Act concerning deemed supplies to and by agents of digital services, unless, that is, Valentina's client succeeds in its challenge to the relevant provisions of the implementing regulation that are currently before the Court of Justice in the Phoenix International case. Category 3, retained EU law, is directly effective rights recognised and available under Section 2 of the ECA, including those derived from the VAT directives under the Becker principles. All of these are saved, as I say, by Section 4. Now, note in passing here that there's no problem with directly effective rights derived from the VAT directive that have already been expressly judicially recognised before the 1st of Jan. There's an open question as to how far this section preserves rights derived from the VAT directives which had not been expressly recognised as directly effective before the 1st of Jan, even where everyone had assumed that those rights existed. Category 4 is retained case law, both Court of Justice and domestic case law, relevant to interpretation and effect of retained EU law. This is retained by Section 6. Category 5 is retained general principles of EU law. For example, rights derived from the principles of non-retroactivity, the protection of legitimate expectations, legal certainty, proportionality, effectiveness, and equivalence. Again, in the context of the meaning and effect of retained EU law. And these general principles are also retained by Section 6. Some points to add here. Section 5 and Schedule 1 to the Act set out exceptions to savings and incorporation. The first concerns supremacy of EU law and the principle of supremacy that we all know and love. The principle does not apply in respect to the disapplication of UK legislation which is passed or made on or after IP completion day. So, for example, if an act is passed on or after IP completion day, which is inconsistent with EU law, which is preserved or converted by the act, for example, a retained EU regulation, that new act will take precedence, subject to what I'll say on section 7A and the implementation of the withdrawal agreement. As far as I can tell, the main primary legislation that the UK has passed to give effect to Brexit in world of VAT was passed or made before IP completion day. The principle of supremacy continues to apply where a conflict arises between retained EU law and pre-IP completion day domestic legislation. That's provided expressly. The principle of supremacy can also continue to apply to pre-IP completion day law, which is amended on or after IP completion day, where that accords with the intention of any modifications. See section 5.3. Next point to note, there are no more references to the Court of Justice from the UK. See section 6. Val and I are on opposite sides of one of the last ones to go from the FTT. Note here, decisions of the Court of Justice prior to IP completion day are binding on courts other than the Supreme Court and the High Court of Justiciary in Scotland. Court of Justice judgments in UK references that are given after IP completion day are binding and to be given full effect in the UK. See Article 89 of the Withdrawal Agreement. And Court of Justice decisions after the end of the implementation period are not binding on domestic courts, tribunals, but those courts may nevertheless have regard to them. Next point to note, leasing and the principle of conforming interpretation continues to apply to retained EU law, either as an aspect of the principle of supremacy under section 5, possibly as an example of a general principle of EU law under section 6, or possibly under both. Next point to note, as regards retained directly effective general principles of EU law, their retention is curtailed in two main respects. First, Frankovich claims are no more. See Schedule 1 to the Withdrawal Act, Para 4. And there are saving provisions for pre-IP completion day Frankovich claims in Schedule 8, Para 39, essentially a 2-year grace period. Next point to note, on or after the 1st of January, no court, tribunal or public authority may disapply any enactment or other rule of law because it's incompatible with any of the general principles of EU law, e.g. non-retroactivity, legitimate expectations, legal certainty, proportionality, effectiveness, equivalence. See Schedule 1, Para 3. And there are saving provisions for pre-IP completion day claims in Schedule 8, Para 39. There's a 3-year grace period, although the scope of the saving, that grace period is far from clear. So as I read it, one can still disapply the VAT Act to give effect to directly effective rights derived from the directives. One cannot disapply the VAT Act to give effect to a right that is derived from, for example, the principle of effectiveness. Note also that the principle of EU law preventing abuse of the VAT system, as in Halifax and Cattell, is expressly retained by Section 6 of the Withdrawal Act. And as if that were not clear from Section 6, the point is hammered home by Section 42.3 and Section 43.4 of the TCTA. And as Val has also referred you to Jack Williams' articles, I too refer you to a particularly useful article by him, which is on the EU Relations website, entitled Retained EU Law, a Guide for the Perplexed. What about the withdrawal agreement itself, including the protocol, I hear you ask? Well, this is implemented directly in domestic legislation by Section 7A of the Withdrawal Act, as inserted by the 2020 Withdrawal Agreement Act. And broadly speaking, Section 7A has the same effect in relation to the withdrawal agreement as Section 2 of the ECA had in relation to the EU treaties, EU legislation and EU law generally. So, net result, the withdrawal agreement is supreme and the direct effect of EU law in the UK is not dead yet. There's been and will be much learned discussion about the effect of the Withdrawal Act and what it all means. I'm not going to enter into that debate now. I'll offer my high-level thoughts on the approach of UK courts and tribunals in the world of VAT, how that Act will be applied in the world of VAT. First, before IP completion day, the law is pretty much the same as before. There may be some arguments that cannot be run post 1st of Jan unless proceedings were started before the 1st of Jan. Next, after IP completion day, the law is going to be much the same as before, save where the rules have necessarily been changed because the UK is no longer an EU member state, subject, of course, to the Northern Ireland Protocol. So there's going to be no year zero approach. I think that continuity will be the watchword in tribunals and courts. Any change will be gradual and organic. Legislative changes must, of course, be given due and full effect, but keep in mind Section 5, namely post-IP completion day legislation is not subject to the principle of supremacy unless the legislation is amending pre-IP completion day retained legislation, and unless the NI protocol overrides it all by virtue of Section 7A of the withdrawal agreement. What about Court of Justice cases decided after IP completion? Again, if it's a UK reference, must be given full effect even if decided after IP completion. There's no problem about that. If it's a judgment that is not on a UK reference, it will undoubtedly be paid close attention, pursuant to the power of freedom on courts and the tribunals to have regard to such judgments. And there may be some parallels here with the approach that courts took to judgments of the European Court of Human Rights. Now, I see that my time is almost up, I'm afraid, and I'm going to tell you before I go about where to find stuff. One of the many challenges presented by Brexit is tracking down the law and working out what it is at any given time. In my slides, there are a number of pages marked where to look, complete with hyperlinks to legislation and resources, which you may find useful. Broadly speaking, the VAT rules have remained the same, and the VAT Act is still going to be your first port of call. There are a number of important changes, mainly driven by the fact that the UK legislation was drafted on the basis that the UK was a member state. Ergo, the UK VAT legislation has been amended to reflect the fact that the UK is no longer an EU member state. And consequently, the UK and those in the UK are no longer able to access EU-only VAT systems. For example, the one-stop system concerning refunds of VAT paid in EU member states and intra-EU simplifications. For example, the mini one-stop shop or MOS for business to consumer suppliers of digital services. And also that the rules concerning intra-EU transactions no longer apply, and that cross-border transactions involving EU member states are now treated the same as transactions between the UK and the rest of the world, with the exception, of course, of Northern Ireland. Now, for your note, the main amending statutes you're going to have to look at are the TCTA, that's the 2018 Taxation Cross-Border Trade Act, which makes amendments to the primary legislation, mainly the VAT Act. You'll need to see Part 3, Sections 41 to 43, and Schedule 8, which makes extensive changes. You note also that the Act confers very wide delegated powers on ministers in Part 5, Sections 51, 52, and 56. Have regard also to the European Union Future Relationship Act 2020, concerning the implementation of the TCA, and have regard also to the Taxation Post-Transition Period Act 2020, which is the act which includes measures to address the operation of VAT in relation to movements of goods involving Northern Ireland. And in particular, this is the act that inserts Schedule 9ZA and 9ZB into the VAT Act. Note also that that act also amends the VAT Act by the insertion of new VAT rules that apply to certain goods sold into the UK by overseas sellers, or sales facilitated by online marketplaces. Realistically, you need a premium commercial online service to keep on top of all this. If you don't have one, I suggest you subscribe to one. Otherwise, it'll drive you mad. Unfortunately, you cannot rely on the official legislation.gov.uk website. It is notoriously slow at updating legislation taking out of amendments. The one ray of sunshine, however, is the gov.uk website. And one of my slides has links to the VAT and customs information and collections available on that website. So you'll find pages listing customs, VAT and excise, EU exit legislation, and customs notices that have force of law. There's also a page in the slides with links to collections of notices. Please check out the gov.uk website. You'll find it very useful. You may also find it useful to subscribe to the gov.uk email service. That's one final plug for my colleagues in Moncton. Do look at the EU Relations website. Now, I see conveniently that my time is long since up. So I'm afraid I'm not going to be able to get into the actual nitty-gritty of changes to UK VAT legislation as a result of Brexit. As I've said, a number of changes have been made as a result of Brexit, basically driven by the fact that the UK is no longer a member state, but the NI, Northern Ireland, is treated as an EU member state as regards goods. As I said, if you keep that in mind, you should not go far wrong when thinking about VAT. I am now, with that wistful heart, going to pass you back to George, and you can now hear about customs.
Thank you very much, Andrew, for that. And his slides will be available on the Chamber's website after this presentation has finished, and they contain links to a whole lot of very useful materials. You may want to copy them as a resource. Ian, one of the features of the Trade and Cooperation Agreement is that there are zero tariffs between the United Kingdom and the European Union. So why is there so much fuss about customs arrangements since the 1st of January?
Thanks, George. That's a very interesting question, and one I may just have covered in a couple of slides that I have for you. Before we look at the slides, I'll just begin by giving a little brief overview of how I'll answer your question, because I've got the wonderful task of trying to cover customs arrangements as they exist post-Brexit in all of about 12 to 15 minutes. Probably a task matched only by Frank Mitchell's task of dealing with Northern Ireland, I think. So what I want to do really is look at what customs arrangements we had when we were in the customs union and when we were in the EU, what we nearly had and what we nearly ended up with in terms of customs, and what we have ended up with, so that we can begin to sort of compare and understand where the new rules fit in. Then I want to look specifically at the question of rules of origin, which is where I'll sort of tackle your question head on, George. Then go on to a couple of the issues raised in practice by rules of origin. And finally, just a very brief overview or look ahead at the future, if we have time, to see what happens next. So if we just turn to some slides. What we had, what we nearly had, and what we have. So just remembering what we've left behind on the left-hand side of the slide. When we were in the EU, of course, we had a comprehensive suite of measures, at the heart of which was the fact that we were in the customs union. Articles 28 to 30 of the TFEU contained the central provisions abolishing all customs duties or charges having equivalent effect between member states. This was, of course, central to the completion of the single market and was jealously guarded by the CJEU. Article 29 showed that goods which benefited from free movement within the EU could be divided into those which originated in the EU or those which originated from outside the EU, but which had complied with the various conditions for free circulation. And specifically, that could be payment of customs duties and charges once they cross the border into the EU, and the various procedural customs requirements, which we're going to have a look at in a moment. Articles 110 to 113 covered provisions where there were attempts to benefit domestic production of goods by taxes discriminating against imports. And of course, Articles 34 to 37 dealt with quotas or measures having equivalent effect, quantitative restrictions on trade. And of course, there were wide or broad exceptions by reference to legitimate aims, but the restrictions had to be proportionate. And those are all well known. And of course, there was a common customs tariff applied, and member states' customs authorities, including the UK, were effectively responsible for policing the EU's external border. What we nearly had, well, there are two scenarios, aren't there? Because under the Prime Minister May administration, we nearly had a facilitated customs arrangement. This effectively was an arrangement which sought frictionless trade on the basis that the common rule book for goods, I suppose, had in some quarters largely been written by the UK and others. It wasn't something that we expected to want to depart from, and therefore the thinking was that it would be reasonable to commit to ongoing harmonisation with EU rules. It would effectively be very close to remaining in the customs union. Then, of course, we nearly had a no deal. Up until the 24th of December, that was a possibility, and of course we know that would have meant WTO rules, and as we all know, and as we were repeatedly told, that would mean tariffs and quotas. And thank goodness we avoided those tariffs, and that's really what George's question is about, I think. What do we now have? Well, Valentin has already mentioned the two provisions, Goods 5, Goods 4, and Goods 10 on the left-hand side. The general rule is indeed that the TCA has created a general rule that there will be zero tariffs, zero quotas on goods moving between the EU and the UK. So that's what we are dealing with. But, and there is a very big but, that only applies, that preferential tariff treatment only applies where those goods satisfy the rules of origin as they cross the border. Rules of origin are really what the problems are all about. So rules of origin, as a lot of people are starting to discover, are essentially rules which enable you to attach an economic nationality to a particular good. And you do so by looking at the input materials and the products. You look at where they've come from, so that what label you can attach to them, it can be determined. And these have, with some exceptions, really been the biggest overall problem that we've encountered in the bedding in process of the TCA since IP completion date. Although, of course, there are specific problems for some sectors like shellfish producers, which relate to different problems. What are the purpose of rules of origin? What are they all about? Well, I think we could think of two main strands here. One is an anti-avoidance provision or purpose, because they're designed to prevent goods which have been manufactured in third countries from being passed through the UK or the EU in order to avoid the tariffs which would be applicable to third country production. So that's a sort of an anti-abuse provision. And then, of course, it's also about maintaining high standards. You can't claim a preferential tariff treatment by buying goods from a country with very low labour standards, for example, just repackage them and sell them into the EU. Now, a lot of people have been very surprised, and a lot of big companies have been very surprised to have encountered these rules of origin problems. Should that have been the case? Well, I think you can look at it in two ways. On the one hand, you could say that it was quite clear after the rejection of the facilitated customs arrangement and all of the other options that effectively we were heading for a fairly basic form of free trade agreement. Now, it's no surprise here that the EU was so inflexible in its approach to rules of origin. The UK in its negotiating position wanted more and wanted more integration. But the EU's approach to these matters has been determined by its approach in other free trade negotiations. And we knew how inflexible they've been, so we shouldn't really have been surprised to find that rules of origin would appear and that they were drawn fairly tightly, because these are a central part of free trade agreements. So on that view, you could say, well, large businesses should have been better prepared. On the other hand, of course, until the 24th of December, government was repeatedly warning businesses to prepare for no deal and to prepare for Brexit, but of course, without those businesses knowing what rules to prepare for until Christmas Eve, which of course spoiled a lot of people's Christmas dinners. And you know, these rules of origin, which were familiar to some trade advisors, and including those in the UK in days gone by, that expertise had simply gone. In the UK, we just don't have the expertise available to deal with these complex matters of bureaucracy. I mean, I remember as a kid, I remember sort of wondering what on earth my dad was doing, but he was essentially a shipping export manager in South Wales manufacturing companies. And he spent all of his time dealing with the various customs paperwork and dealing with trying to get the various pieces of input material through the various ports to deal with just-in-time manufacturing. And effectively, once the single market came along, his job was redundant. So all of that expertise from very long ago has just been lost in the UK. And perhaps then it's not so surprising that we weren't as well prepared as we could have been. And of course, the other point is that until Christmas Eve, some companies were preparing for no deal and maybe took their eye off the ball about dealing with rules of origin. But they've had to find out very quickly what they're all about. These are just a reminder of some of the slides that Val has already introduced. I can deal with them very quickly. You're going to have to look at the specific rules, of course, to understand this. But there are three ways in which products can satisfy the rules of origin. You can have goods which are wholly obtained within the UK or EU, goods which are produced exclusively from originating materials in the UK or EU, or, and here it gets very complicated, they incorporate non-originating materials, so materials which come from outside your country, but which satisfy specific requirements set out in the TCA. At that point, you're going to have to really slow down if you're dealing with a case or an issue about this, because then you're going to have to turn to the, say, 60 or so pages of product-specific rules which deal with the percentages of certain non-originating materials which can be allowed in a product in order to benefit from preferential zero tariffs. Of course, if you can't comply with that, then you are not going to get zero tariffs, and you're not going to be able to say that you've satisfied rules of origin. As Val has mentioned, Val's already explained really this rather unusual concept of cumulation, and the TCA has effectively chosen bilateral cumulation. I understand the UK wanted something with greater integration. You can have diagonal accumulation, for example, with other countries. But essentially, this is very important for the car industry. It allows industries like the car industry, which deal with products going back and forth across the border, which are very closely integrated between the UK and EU, to allow them to count goods which have originating material from the other part as their own, as if they were originating in the UK, for example. And so therefore, it's a provision which enables you to satisfy the origin requirements a little bit more easily. What happened with the major casualty that's been in the news? What about poor Percy Pig? Percy Pig is not alone, because if you're an M&S food hall lover in Ireland, for example, apparently you may be facing problems in relation to 2,000 other products, not just Percy Pig. And this is said to have resulted, or could result in, hundreds of millions of euros in tariffs being payable when you might not expect them to be payable. Essentially, Percy Pigs are confectionery made in Germany. They're then shipped to the UK, but there seems to be very minimal processing done in the UK, from what I can gather. And so they then leave the UK with minimal processing and go to M&S outlets in Ireland and elsewhere in the EU. That is said by M&S to have created a problem where, although there's no tariff payable when the goods are shipped from Germany to the UK, because the goods originate in Germany, so no tariff. When they then go from the UK to Ireland, because of insufficient processing in the UK, you can't claim the benefit of having satisfied rules of origin. So big problems for Percy Pig. As Val has already touched upon, you're going to have to look very carefully at these provisions. I haven't really got time to go through them today, but essentially procedural aspects of the origin rules are going to be incredibly important. There are lots of provisions you're going to need to look at about tolerances. If you just miss a certain percentage, you're going to have to look at certain provisions and so on. It's an enormous task to get on top of these rules. But essentially, broadly, if you're a buyer, you have two ways of trying to claim preferential treatment, one being much better than the other. You can rely on your knowledge that a product originates in the exporting party, but far better to ask the exporter to provide a statement of origin, which effectively certifies the origin. That's obviously going to be much better from the buyer's point of view. And so, as Val mentioned, it's really incumbent upon all companies now to be anxiously reviewing their contracts, their supply contracts, because you want to make sure that you have contractual indemnities and you want to transfer the burden of risk to the other party where possible. For sellers, for exporters, then of course they do have an interest in providing the statement of origin. Of course, this is a massive layer of extra bureaucracy. And of course, it can be very complicated. And when you drill down to the particular product specific rules, particularly where there are non-originating materials, and looking at the complexity of those rules, it's going to be a real headache for the exporters. And some of those statements on origin will be wrong. Lots and lots of complexity and problems. Frank has the wonderful task of dealing with Northern Ireland, although thankfully for him, he'll probably only have about 30 seconds to touch upon those differences and the extra layer of complication in Northern Ireland. I won't deal with it today. But you can see already that the complexity and cost generally of complying with all of these rules of origin and of course the additional customs procedures, because we haven't got frictionless trade. It's not just about tariffs. We also have to satisfy all of the customs procedures and checks that come from us being a third country. But sometimes the solution to a particular problem that you or your client will find will simply be that it is simply more cost effective just to pay the tariff rather than try to deal with the extra layers of complexity of complying with rules of origin. Just to take one example of how difficult these rules can be, if you drill down and look at the classification of goods, and then you find the 10-digit commodity code set out in the statutory instrument in the UK, we've currently retained the EU commodity codes, and though of course we are allowed to diverge in the future. But I happen to know from a case I've been involved in for HMRC over the last 4 years, where the Commission was claiming nearly 3 billion euros in customs duty from the UK in an infraction. I happen to know an awful lot about these commodity codes in areas like textiles and footwear. far more than anyone should really have to suffer. And you might have to decide whether a particular good is knitted or crocheted, or is it woven or non-woven? And these are interpreted in all kinds of different ways. Just a point on one of the Q&As that came up, I noticed, retained EU case law on the classification of goods. Now, the Withdrawal Act 2018, as Andrew touched upon, says that CJEU case law at IP completion day is binding on our courts, subject to any modifications that ministers may make. Question was asked in the Q&A box, well, what happens about case law of the CJEU in the future after the so-called fossilized state of EU law has been retained? Well, the answer to that is in Section 6 of the EU Withdrawal Act 2018, because UK courts are not bound by any future decisions of the CJEU, but may have regard to them in the future. But that's an example where the Court of Justice case law past and potentially in the future is going to have to continue to be used in resolving all of these difficult issues of interpretation of an issue like commodity codes. So I think I've just run out of time. So just as a tantalizing tidbit for the future, is this state of affairs forever? I would say it could get worse before it gets better. See the grace periods which are coming to an end in April and July, which I've mentioned on the slide. I think there are going to be big problems in those months as the easements are ended. More optimistically, I think things could get better because there are so many provisions in the TCA which allow for example, the Partnership Council to deal with changes or disputes or improvements. An issue like Percy Pig is a feature of the TCA, so that would require a change in the agreement, but it's surely in both parties' interests for that kind of problem to be resolved at some point in the future. But that is the law as it is, and it's unfortunate. And then finally, it could also all fall apart, and that's the ultra pessimistic view, because of course the deal could be broken down and it could be departed from. But you have to look at the Northern Ireland Protocol in all of this because it's so central to underpinning the deal, and unless we have a better solution for something which is designed to maintain peace, we are at the moment unlikely to depart from it. Thank you very much.
Well, thank you very much, Ian, for that. And you've heard throughout these talks people mentioning the phrase "except Northern Ireland." So that brings me on to Frank Mitchell, SC, who's going to have the very straightforward task of explaining Northern Ireland in around 10 minutes. Frank.
Thanks, George. The easiest and perhaps most obvious place to start when trying to get to grips with trade with Northern Ireland is the relatively straightforward concepts from quantum physics. Schrodinger's cat is a thought experiment that illustrates an apparent paradox of what is known as quantum superposition. And the cat exists inside a box obscured from view. And on an application of the principles of quantum superposition can be said to be simultaneously both alive and dead. And the reason I mention this is that it may assist you to think of Northern Ireland as the Schrodinger's cat of international trade. Northern Ireland is both inside the EU and outside the EU at the same time, but perhaps more confusingly, it is simultaneously both a part of the EU's single market for goods and expressly subject to the Union Customs Code and EU trade remedies legislation, while being part of the UK VAT area and, at least according to the protocol, the UK customs territory. The Republic of Ireland, of course, is a member of the European Union, and the Northern Ireland Protocol was designed to protect the Good Friday Agreement in order to prevent the return of a hard border on the island of Ireland and to protect the all-island economy. So while Northern Ireland remains part of the UK's customs territory, allowing business in Northern Ireland the vaunted unfettered access to the UK's market and to benefit from any trade deals agreed by the UK, the protocol creates a unique scenario whereby Northern Ireland remains part of the UK VAT area and customs territory, but also has access to the EU single market. And trade with Northern Ireland will be governed by the protocol for at least the next 4 years. In considering what this means in practical terms, it's sensible to try to separate VAT and customs duty. Now, obviously, in the 6 or 7 minutes available, I can only do this at the highest of levels. But from a Republic of Ireland or EU perspective, other than the requirement that Northern Ireland traders use an EORI number starting with XI, very little has changed in terms of trade in goods between the Republic of Ireland or any other EU member state and Northern Ireland. More or less the same rules as applied before Brexit continue to apply now. That means there's VIS and Intrastat for goods and EU simplification measures such as triangulation, self-billing, margin schemes, call-off stock, etc. One interesting curiosity is that whereas Great Britain now has enhanced flexibility in terms of determining its own VAT rates for supplies of goods, Northern Ireland is bound by the EU rules. But under Article 8 of the protocol, the UK is entitled to apply to supplies of goods in Northern Ireland the VAT exemptions and reduced rates that are applicable in the Republic of Ireland. In terms of trade between Northern Ireland and Great Britain, there have been significant changes in that the rules which apply to transactions between those two territories, and in particular then as regards trade which also involves another EU member state or an EU member state. Where goods are sold from the UK to Northern Ireland, the seller issues a VAT invoice to the Northern Ireland purchaser in the normal manner as he would for domestic sales. The seller accounts for VAT on his return, and even though that is in reality import VAT, it's treated as though it were output VAT, and the Northern Ireland purchaser can obtain a VAT input credit subject to the usual rules. And there are exceptions to these rules, such as where certain customs procedures apply. And of course, a lot of different variations on that theme. A particularly challenging complexity arises where a UK VAT registered business moves its own goods from Great Britain into Northern Ireland. So, and essentially what has happened here is that the UK have sought to introduce measures ameliorating the difficulty this causes, but the EU have not. Therefore, where a business transfers its own goods from GB to Northern Ireland, because the EU VAT rules come into play, the business has to account for output taxes as if it sold the goods to a third party. And this can give rise to a particular complexity for exempt businesses, but they have been largely dealt with by the new paragraph 31A of Schedule 9 ZB that Andrew referred to earlier. However, notwithstanding the complexity of transferring own goods from GB to Northern Ireland, movement of the goods the other way around from Northern Ireland to GB does not have the same requirement to account for output tax unless an actual supply takes place. UK VAT grouping is theoretically still available, but in essence, where goods are supplied between members of a VAT group and the goods move from GB to Northern Ireland, they're treated in the same way as when a business moves its own goods. In other words, the VAT grouping provisions don't apply. There are complexities around EU simplifications, which are by and large not applicable as regards trade between Northern Ireland and Great Britain, but there has been a carve-out introduced very much at the 11th hour on the 14th of January for the margin scheme and as it applies to car dealers in Northern Ireland. And that in essence is the easy part. And in the next 3 minutes, it's customs duty. And it helps to think of customs duty completely differently for movement of goods from Northern Ireland to GB, and then separately movement of goods from GB to Northern Ireland. In terms of moving goods from Northern Ireland to GB, a special regime has been introduced in order to ensure the promised unfettered access by Northern Ireland companies to the remainder of the UK. And in its simplest terms, there's a new regime for what are known as qualifying goods, and these are goods in free circulation in Northern Ireland. And if you move qualifying goods from Northern Ireland directly to the rest of the UK, there's no changes and no customs processes for almost all traders, with some very limited exceptions. Where the exceptions do apply, you need to submit an export declaration for a movement of goods between Northern Ireland and the UK. In terms, though, of movement of goods from Great Britain to Northern Ireland, that's where it gets significantly more complicated. When goods are brought into Northern Ireland from Great Britain or from any other country outside the EU, there is a need to make declarations, and there is a possibility of tariffs applying. Tariffs can apply where the goods are considered to be at risk of leaving the UK customs territory and entering the EU's single market. And the way this manifests itself is, in essence, that you pay no duty if either you're able to claim a preferential rate of duty under the TCA, if you're authorized under the UK trader scheme and declare that your goods are not at risk of onward movement into the EU, or you're eligible to claim a waiver on the duty up to specified limits. And when bringing goods into Northern Ireland from outside the UK and the EU, traders will pay the UK rate of duty rather than the EU rate of duty if the goods are not at risk of onwards movement. At the highest level of generality, there are two ways that goods brought into Northern Ireland from GB are not at risk. And the first is if there's a zero rate of tariff under the EU rules. And the second is if the goods are for sale to or final use by end consumers located in the UK and are brought into Northern Ireland by a trader authorised under the UK Traders Scheme. The at-risk tests are complicated and they need the score to be familiar with the rules of origin that Ian outlined earlier. In terms of the future, there are those, in terms of the future, those who are in a position of having to consider trade with Northern Ireland are having to think about VAT and customs duty as part of a single problem. And this is bringing focus on the Incoterms and the precise point at which title to goods transfers. Northern Ireland has been operating under a grace period afforded to it by the EU as respects food and certain other items. And this is due to come to an end in April. Yesterday, the Joint Committee met, but there is as yet no agreement on the extension of the grace period. Ultimately, however, whilst teething problems remains, it is certainly possible to view Northern Ireland as in an enviable position. Depending on the form that phase 2 takes, businesses established in Northern Ireland will be both within the European customs territory and have unfettered access to the UK. And I think that there are many who see this as putting Northern Ireland in a very strong position so that the position and the complexity may not be all that bad.
Thank you very much, Frank. And that, I think, brings our series of talks today to an end. Thank you all very much for listening. As I said earlier, there will be slides available on the Moncton Chamber's website in due course, probably later today. And you can please feel free to access those and use them to as a useful resource with all sorts of useful links and so on them. But it only remains for me to thank our 4 speakers for their excellent talks and to thank you all for attending. Goodbye.